a small bio I'm going to read for Christine, and then with that, I'll hand it over to you. So Christine's practice is devoted to the areas of labor and employment law, tax litigation, and related litigation. Christine represents unionized, non-unionized employers and all aspects of labor and employment law. She's thoroughly versed in issues surrounding the employment relationship, from hiring, discipline, compensation, performance management, workplace health and safety, human rights, through to termination. In regard to her unionized clients, Christine has acted as the lead negotiator in collective bargaining and has effectively represented employers in regards to grievances and arbitrations. Christine is frequently engaged in the preparation of employment contracts, manuals, and policies, conducting workplace investigations, and providing client training workshops. She also provides advice and advocacy to executives and professionals on employment matters. And in the area of tax litigation, Christine provides representation to taxpayers at every stage of the dispute, including the objection stage, at the appeal stage, on applications for judicial review, on rectification applications, for remissions orders, the list goes on, and in regard to requests for taxpayer relief. Christine is particularly focused on providing representation in regards to business-related tax disputes, such as the improper assessment of independent contractors as employees, the denial of valid business claims, expense claims, and director assessments. Prior to joining Wilson Vukelich, Christine articled with the Ontario Ministry of Labour. So just a couple of things to note before I hand it over to Christine. We're going to be taking questions down in the chat below, so you can see the chat box if you hover your mouse around the bottom. We're going to keep them all until the end though, so please feel free to list your questions in there as we move through the webinar today, and Christine will address them at the end of the presentation. I'll also throw a quick hello to Talia Lane. She's one of our directors for 2020 for the Ajax Pickering Board of Trade. And we also have Joan Weidman here with us, who's the chair of our Government Relations Committee. So hello to you ladies as well. And with that, Christine, I will hand it over.
Okay, thanks very much, Nicole.
You're welcome.
Good morning, everyone. So,
Good morning.
Oh, sorry, I can't, it doesn't let me share my screen. Sorry, Andrew, do you mind?
You should just click the share button. You should see it.
It says host disabled participant sharing screen.
Okay, just 1 second, please.
Yeah, no. All right, well, I'll just talk for a second. So as Nicole mentioned, the purpose of today is going over what your options and obligations are as an employer during this difficult time. For some of you, you will have closed your workplace, the physical operation. You might have continued on a remote basis. You may have laid off employees. For others, you may have continued your operations throughout this, but it's likely taken some changes. It could mean that some of your staff have been laid off or on vacation, or it could mean that some of your staff are working remotely. As we continue to move forward during this pandemic,
yeah, I don't know if you can't share it. I haven't done anything.
Okay, it's letting me know.
Try it now, please.
Thanks, Andrea. As we continue to move forward through this pandemic, you'll have to make sure that you continue to comply with the obligations and options that are set forward by the government, which continue to change on a day-to-day basis. Now, just as a few notes before I start, the purpose of this webinar is to address your options and obligations during the pandemic as an Ontario employer that's not unionized. So if you are unionized, you should keep in mind that your collective agreement will likely change or add to your obligations and options, in particular in regards to layoffs. You should also be mindful that if you have operations outside of Ontario, there'll be different laws that apply. Now, in many areas of law, of HR law, Ontario sets the bar or is the same as most other provinces. So for example, in regards to workplace violence and harassment. But on areas that are touched on by the pandemic, such as layoffs, the obligations in law vary substantially province to province. So you really do need to be cognizant of what that particular province requires of you, including whether that particular province is allowing you to remain open. All right, so here's the agenda of what we're going to be going through today. So first I'm going to be talking about changes in your workplace in dealing with your change need, labor needs. So we'll talk about layoffs and part-time hours and the potential claims for constructive dismissal. Then we'll move into dealing with your health and safety obligations and the potential for work refusals underneath the Occupational Health and Safety Act. And then finally, we'll go into addressing workplace attendance and accommodation in regards to the pandemic. Okay. So because of the pandemic, many of you have probably experienced a change in your workforce needs. It could be that you've seen a decline in the amount of business that you're getting, or in a reduction in your cash flow, and as a result you need to implement changes. So there's, generally speaking, 7 options that you have as an employer during this time. The first is the payroll subsidy, and there's currently 2 payroll subsidies. One is a 10% subsidy that was originally announced, and the second is the 75% subsidy, known as the Qs, and that is currently rolled out, but requires it has more restrictions in terms of eligibility. In particular, you'll need to have seen a 15% drop for March and a 30% drop for subsequent periods. Your second option is to schedule week-long vacations. So the Employment Standards Act allows you as an employer to schedule vacations, provided that there are week-long periods, not a day here, a day there. But employees can certainly elect to use a day here, a day there, if, for example, you decide to reduce days of work. Your third option is to place employees on an unpaid leave. So underneath the new section 50.1 of the Employment Standards Act, if you're concerned of the health or safety of your employees, or just complying with an essential services order, you can place your employees on an unpaid leave instead of a layoff. So for those of you whose business is currently closed down, for example, a hair salon, you could have your employees placed on an unpaid leave instead of doing a temporary layoff. The fourth option is to reduce hours of work. So it could be that you're going to tell your staff that they're going to go down from a 5-day work week to a 4-day work week. Your fifth option is to reduce compensation. So that could mean that they're still working 5 days a week, but they're now going to see a 10, 15, or 20% drop in their compensation. And the drops that we're seeing varies industry by industry. More professional services, such as lawyers and accountants, tend to be doing around a 10 to 15% drop, with some holdbacks where they don't provide drops for individuals earning a certain level of salary. Whereas in other industries, such as construction, 20% is currently the common. The sixth option is to temporarily lay off employees, and I'll get to that in a bit more detail. And then the seventh option is to dismiss employees. And for that option, it's important to note that there's a provision or a notion of frustration, which is where if the employment agreement cannot, or if the employment relationship cannot continue for reasons beyond your control, it is possible that you may be able to claim frustration underneath the Employment Standards Act and not have any termination entitlements owing to employees. We currently don't have a position from the Ministry of Labor as the interpretation of that provision. Previously, us employment lawyers all thought that frustration would be used for something like a tornado comes down and destroys the workplace, and so the workplace can't continue to operate. But arguably, because of COVID-19, it's possible for some businesses in certain industries that they may be able to claim frustration. Now, when you're deciding which of these 7 options to go with, you don't have to choose one and stay with it. You can choose different ones for different employees. So it could be that in your workforce of 150 staff, you pick some to just go on scheduled vacation, some to do reduced work weeks from 5 to 4, some to be laid off. Then you can move that around. So some people who were on reduced work week might get laid off. So there is some flexibility, but those are essentially the 7 options. When you're deciding which of those options to use, one thing that you really do need to be mindful of is this concept of constructive dismissal. So effectively what that means is whenever you make a unilateral change to the terms and conditions of an employee's employment, that employee can claim they've been constructively dismissed. In other words, that they've been effectively fired. So as an example, if you lay someone off and you hadn't previously confirm that right to do so, for example, in the employee handbook, the employee could claim they've been constructively dismissed. Now, if an employee is dismissed, they have two types of termination entitlements normally. The first is an entitlement underneath the Employment Standards Act, and that's a statutory minimum entitlement. And the second is an entitlement at common law. That's where the judge looks at different factors, their age, their length of service, their position, and so forth, and decides what amount of notice they should receive. Now, you can have an enforceable employment agreement that limits your employees to only their Employment Standards Act entitlement. But if you didn't do it, you didn't have the agreement, then employees are entitled to both the Employment Standards Act and their notice at common law. Now, if an employee quits and claims they've been constructively dismissed, then they've resigned and are entitled to nothing unless they can prove that they were in fact constructively dismissed. So the claim of constructive dismissal is a bit of a gamble for any employee to take. The other thing is that, so remember I talked about those two types of termination entitlements, the Employment Standards Act and the common law. Well, the common law entitlement is subject to mitigation. In other words, if Susan is entitled to 8 weeks underneath the Employment Standards Act, she gets that, even if she goes out and gets a job the very next day. But if Susan is also entitled to 10 months at common law, and she goes out and gets a job at the 6-month mark, and that job is paying her $1,000 less per month, then for the first 6 months, she'll be entitled to her full pay. But for the balance, she'll only be entitled to the shortfall, being the $1,000 per month. So as an employer, if an employee correctly claims constructive dismissal, it means that you can offer them their job back or new reasonable employment. And if they don't take it, the court will reduce their damages because they failed to mitigate. And if they do take it, the court will reduce their damages because they did mitigate. So generally speaking, a lot of businesses currently are engaged in conduct that outside of COVID-19 we would have all said was constructive dismissal, and employees likely would have claimed constructive dismissal. Because of the current economic climate though, most employees are reluctant to claim constructive dismissal. Further, many of us believe that the courts will eventually find that because of the pandemic, employers had sort of additional rights than they normally do in order to lay off, provided they're acting reasonable. So, I'm seeing some companies that are doing 10 or 15% pay decreases across the board because they have to. And I think that the court might find a way to allow that without entitling employees to a claim of constructive dismissal. Whereas I'm seeing other companies lay off employees and force them to work while on layoff without pay. I don't think any court's going to be happy with that kind of conduct. So if as an employer, you do have an employee who claims constructive dismissal, you have 3 options. Your first is to reverse course. So let's say you were going to go down from 5 days to 4 days, and the employee says, I'm going to claim, that's going to amount to constructive dismissal. You can't do that. You might just say, you know what, never mind, you go back up to 5. Or you might maintain, no, it doesn't amount to a constructive dismissal. Or you might maintain, even if it does, you still have a duty to work the 4 days because you have a duty to mitigate. So there are a few options, even if an employee does claim constructive dismissal, which I find right now is not that common. So as I mentioned before, one of your options is to lay off your employees. And that's currently the most common option that's exercised to some degree. I find that most workplaces first look to things like vacation and reduced days before jumping to layoffs. But for other workplaces, the layoffs has to occur, especially those in certain industries, such as restaurants. So in Ontario, there's 2 types of layoff streams. So the first one is that you can place employees on a layoff for up to 13 weeks in a 20-week consecutive period. And there's no additional requirements to do that beyond the potential claim of constructive dismissal. The second category is if you're providing them with some sort of compensation or continuing their benefits from the outset, then you're able to lay off for 34 weeks in a 52-week period. And I'll note that all indications are that we're going to go through waves of the pandemic until we have an immunization in place. So I do strongly recommend that if you're going to lay off employees, that you have the benefits in place so that you have that 34 weeks in a 52-week period. Otherwise, you're going to be capped at the 20-week period, which may be problematic if another wave hits in the coming weeks and months. Now, also note that the government is currently reviewing extending that 13 weeks, and other provinces such as Alberta have doubled their minimum. So it's quite possible that 13 weeks is going to shortly jump to 26 weeks. Now, if you do lay off an employee, there's two types of government programs they can now apply for. I feel like I'm saying there's two of everything a lot, but that's just the way the law is apparently. So the first type is that they can apply for EI, and the second thing they could apply for is the SERB. So EI is your regular EI. You get it, the employee can get it if they've been unemployed for at least 7 days. And they are eligible then for $573 per week up to 45 weeks. And the EI benefits are taxable, which is one area that we're actually worse off than the US, oddly enough. And the current processing time is about 6 weeks for EI benefits. The other type of benefit program is the SERB. And that's a taxable benefit of a flat $500 per week up to 16 weeks during set 4-week periods. The 4-week periods are not mentioned in the legislation anywhere, but the government is just implementing 4-week periods in order to match the Canada Emergency Wage Subsidy 4-week period to avoid a potential issue where people are getting the SERB and the CEWS at the same time. Now, because the SERB is calculated differently, what this means is that for individuals, generally speaking, who earn less than $1,040 per week, the SERB gives them more money. So they should apply for the SERB first, and then if they remain on layoff past the 16 weeks, they should then switch over to EI. The other thing of interest is that the SERB is eligible for both employees and business owners, which EI is not. So in order to receive the SERB, unlike EI, which only has a 7-day period of unemployment, the SERB requires a 14 consecutive day period of unemployment. For the first application period, the applicant must earn less than $1,000 during those 14 days. And for subsequent periods, they have to earn less than $1,000 during the relevant 4-week period. So it's very important for employers when making layoff decisions that they keep in mind what these blocks are so that they don't inadvertently just unentitle an individual to the SERB by paying them more than they should be paid, or by, messing up the layoff date. Now, as an employer, you might find that as we sort of reopen and re-ramp up, that you need more workers than you did in the weeks before, but you might also find that you don't need them to work full-time hours. So effectively, you have 3 options to deal with that. Your first option is if there were employees on layoff, you can recall them from layoff and have them reduce work hours. If they weren't on layoff, you can just simply schedule them to work reduced hours. Option number 2 is to have employees remain on layoff but still work part-time. And then option number 3 is to do the government work sharing program. So underneath the second option, to have employees remain on layoff while working part-time hours, how that works will depend on which program they're under. So if the employee applied for it and is receiving EI benefits, what that means is that you can have them work up to 39% of their previous hours, and their EI benefits will be reduced by 50 cents for every dollar that they earn with you. If the employee is receiving the SERB, then you can have that employee work part-time while on layoff, but they cannot earn more than $1,000 during the relevant 4-week period. So because of the 2 very different restrictions in regards to EI and the SERB, it's very important that if you're going to have employees work part-time while on layoff, that you confirm whether or not they're receiving the SERB or EI. Now, the third option that I mentioned is doing a work sharing application. So work sharing is a program that existed long before the pandemic, and it provides that if you and your employees agree, you're able to have their hours of work reduced while providing for sort of an EI top-up, as it were, to compensate them for the wage shortfall. And there's 3 conditions in order to qualify for the work sharing. You have to see a recent and temporary 10% decline in business, which I'm going to guess about 90% of businesses have out there. You have to have your core employees consent to a 10% to a 60% reduction in pay. And you have to have a comeback plan, which I guess is COVID is addressed. There used to be waiting period and further restrictions in regards to the work sharing program, but my understanding is that those businesses who've applied in recent weeks very quickly received approval from the government. So I've done the math for you and just giving you 2 examples of how it would work underneath the layoff partial recall option and the work sharing program. And as you can see here from the numbers, employees will always get more money underneath the work sharing program than they will with a layoff and a partial recall. So if possible, if it makes sense, so you have a mass layoff situation, the work sharing program is preferable. But if you need to be more flexible, where only some individuals are laid off and others are not, then the layoff and partial recall is going to make more sense, even though it won't put as much money in the employees' pockets. Okay, so that's the first portion of the 3-part sections that we're going to go through. So you now sort of have an understanding of what your options are for dealing with your workforce needs during the pandemic. Next, we're going to talk about health and safety obligations during the pandemic and making sure that, as you continue to have workers come back, whether it's on a part-time basis or a full-time basis, that they're coming back to a safe workplace that complies with the Occupational Health and Safety Act. So it's a quick intro. The Occupational Health and Safety Act sets out the general regime for ensuring workers' health and safety in Ontario. And it's enforced by the Ministry of Labour through things like inspections, investigations, and prosecutions. For employers, the most important provisions of the Act are sections 25 and 26, which generally say that you as an employer have to take all reasonable precautions to protect the health and safety of your workers. And that includes providing all the equipment and the training and the instructions that they need to do their work safely. Now, these provisions are further defined by other sections in the Act, as well as through regulations. So they might say, not only do you have to do everything reasonable, but you definitely also have to do X, Y, and Z. Currently, though, we don't have that X, Y, and Z. We don't have specific regulations or specific provisions in the Act in regards to COVID-19. So instead, when deciding what you need to do in order to make sure that your workplace is safe, you have to simply do everything that's reasonable. And because of how broad that language is, it certainly can be overwhelming for an employer to try to determine what it should be doing. Now, the Ministry of Labour has tried to provide some help, although it's not yet in a position, apparently, to amend the regulation. It is in a position to share guidelines. And so far, over 60 guidelines have been shared by the Ministry of Labour that were created by various industries. Now, all of these guidelines make it very clear they are not law, they're not legal advice, they are not binding on you, but the fact that the Ministry of Labour is sharing them would certainly give them some weight that you should take them into mind when determining what's a reasonable thing for you to do in order to ensure the health and safety of your workers. So generally speaking, what should you be doing in order to comply with your OSHA obligations in regards to COVID-19? So 1, you should have in place posters up in your workplace. You can use some of the government free posters. I also like the Canadian government has some great ones on physical distancing and what it means. But you should have posters up in your workplace. Number 2, you should have policies in place. And I'm going to go through what should be included in those policies in a minute. But you should have policies in place that deal with how you're going to protect everyone's health and safety during COVID-19. Number 3, you should have procedures in place. What happens if there's an incident of COVID-19 in your workplace? Number 4, you should be providing training to your workers. And that means, simply put, that you're sharing the posters, policies, and procedures, that you're answering questions, that you're reminding people about taking the steps that they need to in order to protect their health and safety and everyone else's around them. And then finally, you might need to have personal protective equipment, or PPE, depending on the nature of your workplace. The other thing that you should be using and pointing your employees to is the Self-Assessment Questionnaire. It's a questionnaire that was created by the government and allows every individual to go online and check to see whether or not they should be self-isolating. We also know from the news over the weekend that if anyone is concerned at all, they should go and get tested and can go and get tested now. But I find that the self-assessment questionnaire is very helpful for individuals who are just concerned, especially when they read in the news. We know, for example, that 2 individuals in a downtown Loblaws have tested positive, and things like that can cause people to become concerned. Does that mean that I now need to self-isolate? Well, we know from this questionnaire that unless you were within the 2-meter distance of a person who's tested positive for more than 15 minutes, the public health does not consider that to be a close contact incident, and therefore you will not need to self-isolate unless you have symptoms. So it's things like that that you learn by taking this questionnaire. So it's a great tool for businesses to use in order to help address any concerns. So as I mentioned, you have your posters that you want to put up, then you have your policies and procedures. So depending on the nature of your workplace will depend on what these policies and procedures look like. For some workplaces, if you're a small operation with 5 individuals, you're probably just going to have 1 document. If you are a large-scale business that has over 150 employees, you have some office staff, some warehouse, you may want to have multiple policies and procedures so that you have policies that are relevant to the office workers and policies that are relevant to the warehouse workers. Generally, what it should look like is your policy should address how things are going to work on a day-to-day basis in the office or in the workplace or at the construction site. And I like those policies to be, fairly short and sweet. At our office, it's a 3-page document that gets posted up in various areas within the workplace. And posted up so you don't have to flip the pages anymore. We can't do what we used to do where something was pinned to a bulletin board and people had to touch the document. Minimize touch points. Your procedures, though, should deal with the more complicated matters, such as how you're going to handle an incident of COVID-19 in the workplace or a potential incident. And that's more like an instruction manual. So what I've done now is I've gone through all the guidelines and I've pulled from them the consistent language that's in all of them that generally, in my mind, indicates what all employers should be doing if they're not operating on a purely remote basis. So these guidelines include that all workers are supposed to have their temperature taken, and that can either be before coming into work or when they get there. There should be restrictions in place as to who can enter the workplace. So for example, individuals should not be allowed to enter if they have been ordered to self-isolate. The policy should confirm the physical distancing required. The policy should remind everyone to regularly wash their hands, to wipe down and disinfect their workstations, to avoid in-person conversations, to avoid sharing physical documents, to address what happens when documents or packages or otherwise are exchanged. For some workplaces, it might be that you provide gloves, but given that gloves are not always easy to obtain these days, it might be that you want to focus on having individuals wash their hands immediately afterwards. You should address sharing tools and equipment, that they should be, once again, it should be avoided, and then they should be wiped down. So for an office space, you might want to have in there a recommendation that disinfectant is used to wipe down the keypad on the photocopier before it's being used. You want to remind your workers to save and organize things so that a colleague can take over if needed, and that everyone effectively packs up at the end of each day as though they might not be able to come back the next day, especially for those workplaces who have just been allowed to reopen as of last week. With the current incidences of COVID-19, it's possible that we might roll back again. You must also require that everyone wear proper PPE. And for those workplaces where the N95 mask isn't required, fabric masks are currently being recommended by the government. And it would certainly seem that if you have any workers who can't maintain the 2-meter distance, that they have to wear fabric masks. And that's what some employers such as TTC are doing. For workplaces that have to pick up or deliver items, there are specific guidelines that the government has provided that should be incorporated in your policy. For workplaces that have clients or customers entering, again, we have specific guidelines. We're seeing a lot of guidelines that indicate all visitors should be, for example, using hand sanitizer before entering the place of business. Now, that's your policy. So your policy is supposed to be, 1, 2, 3 to 5 page document that deals with the day-to-day operations that people should be looking to just sort of figure out how to do things. You should also separately have a COVID-19 procedures. Now, some businesses are creating a standalone, and other businesses are just putting a pandemic response provision in their employee handbook. How you do it really depends on the nature of your business and how you want to have things done. There's no right or wrong way, but I guess there is the wrong way of not doing anything. Now, for your procedures, you should be dealing with things like the management of workplace traffic. So if, for example, you operate a busy industrial operation, you're going to want to have an actual picture of the workplace and have where each person's workstation is going to be, how you're going to deal with things like lunch scheduling and that sort of thing. For our office, for example, we've turned into one-way hallways so that because at the end of the day, you cannot maintain sufficient distance within a hallway, so everyone has to move in one direction. And then you also want to deal with what happens if there's an incident or suspected incident of COVID-19. And that should really be addressed just like you would sort of a fire or an emergency plan. Step 1, we inform these people. Step 2, we inform these people. Then we do this, and then we do that. And then once you have all this in place, you want to provide that training that I mentioned to you beforehand, where you communicate this all to your workers. Now, underneath the Occupational Health and Safety Act, in addition to establishing obligations on employers, and workers as well, it also establishes rights for workers. And the rights fall into 3 categories. 1, the right to participate, so they are able to form health and safety committees or become a health and safety rep. There's also the right to know, and that's through things like training, instructions, and posters. And then finally, there's right to refuse work. And that's where if the worker believes that there's a hazard in the workplace, they can refuse to do work until the matter is addressed. And I should note that certain workers, such as healthcare workers, have restrictions in place, whereas they're not able to refuse unsafe work if it's part of their normal job, or if the refusal would endanger the life of someone else. Now, if a worker exercises their right to refuse work, so they say, you know what, I just don't think you guys have put in enough steps to protect me from COVID-19. I'm not going to come into work right now. Then what needs to be done is you need, as an employer, to do an investigation. You should have a form that you fill in saying, here's what the worker said. The worker on X date refused to work because of these concerns. Then you conduct an investigation. We looked into it, and according to these government resources, we're only required to do X, Y, and Z, and we have that in place. Or we looked into it, and the government requires us to do X, Y, and Z, and we didn't have Z in place, but now we do. And then inform the worker of the results of that investigation. If the worker then continues to disagree and feels that the hazard still exists, the Ministry of Labor will need to be contacted, and the Ministry of Labor will make a determination as to whether or not the work refusal is correct or not. And at the end of the day, if the Ministry of Labor concludes there was a hazard, an order will inevitably be issued. You'll have to comply with that order. And then once everything is satisfied, the worker comes back to work. If the Ministry of Labor concludes there wasn't a hazard, then the worker has to come back to work. But eventually, all roads lead to the worker coming back to work. We know that the Ministry of Labor has responded to several work refusals. 2 of those were fairly public, one involving TTC workers, another involving a Windsor assembly plant. In both instances, the Ministry of Labor determined that the work refusals were of basis. For the TTC, they reviewed their health and safety policies and procedures in place in regards to COVID-19 and found them to be satisfactory. And for the Windsor workplace, the Ministry of Labor determined that there was no basis to require everyone to self-isolate because a coworker had been exposed potentially to COVID-19. And that's where that assessment questionnaire comes up again, because underneath it, if they had answered the questions, they would have seen, because they didn't come into close contact with their coworker, there's no basis for self-isolation. Okay, so you now sort of understand your options to deal with your change in workforce needs and what you have to do in order to ensure a safe workplace as Ontario continues to reopen. Now we're going to deal with that third sort of pinch point that many employers are feeling, and that's what to do with just general employee attendance and accommodation requests. So while many employers are seeing pushback from employees and coming in because they're concerned about whether or not the health and safety obligations are complied with, the other pushback that employers are seeing is that employees don't want to come in or can't come in because things such as the employee's own health issues, such as immunocompromised, or the employee's childcare needs, because the daycares and camps have yet to reopen. So generally speaking, as a first starting point, as an employer, you should make sure that you have your attendance policies in place, and all employees are continuing to comply with those, even if they're working remotely, and especially if they're working remotely. You don't want to run into any issues where there's a challenge over whether or not someone was or wasn't working on a particular day, or is or isn't entitled to overtime pay. So you should continue to ensure that you know each individual employee's hours of work and when they were working, and have employees report when they're ill or unable to work, even if they're working remotely. Now, if an employee tells you that they need or want to be absent or need or want to work remotely, then there's 4 things that you have to be mindful of. The first is that your employment agreements or your employee handbook might provide for paid personal days and paid sick days. Many employers, as a result of Bill 148, which now seems like a lifetime ago, introduced paid personal days and did not back those out. So if you have those still in place, do keep in mind those entitlements, and remember that if an employee doesn't get them paid out, it may impact their eligibility for the CERB. The next is that OSHA work refusal we just talked about. So if an employee says they have to be absent, they can't come in, you have to keep in mind, is this actually a work refusal underneath the Occupational Health and Safety Act? The third thing is to keep in mind is the leave entitlements underneath the Employment Standards Act, and I'll go through those in a minute. And the fourth thing is the fact that underneath the Human Rights Code, an employee is entitled to accommodation, which can include a leave of absence in regards to protected grounds, which for COVID-19 purposes, we really focus on disability and family status. And that entitlement is up to the point of undue hardship. So let me focus on those last 2, the Employment Standards Act and the Human Rights Code. Underneath the Employment Standards Act, there's no paid leave day entitlements with the exception of sexual and domestic violence. For the unpaid leave days, there's 3 categories you need to be mindful of. The first is 3 unpaid days for personal illness, personal issues. The second is 3 unpaid days for family issues. And the third is the new one, which is unpaid days under Section 50.1, which is sort of that pandemic provision. And the pandemic provision says that effectively, if they're receiving care because of COVID-19, if they're caring for someone who is infected, if they're required to self-isolate, if they can't get back into Ontario, or several other prescribed reasons, but those 4 are the main ones, then they're entitled to a leave under Section 50.1 for as long as it takes. Now, what's important to note is that for the purposes of this leave provision, you can only ask for reasonable documentation. You cannot ask for a doctor's note, just for that leave provision. The other thing to note is that because of the new Section 50.1, you as an employer can place an employee on an unpaid leave of absence if you're concerned. So if you have an employee show up to the workplace and they're coughing, they have a fever, the response should be, okay, you're going to leave the workplace, you're going to go do the self-assessment questionnaire from your car. If you need to self-isolate, or it's recommended that you do, then you're going to be placed on an unpaid leave underneath section 50.1. And based on what the government has now said, you might also want to recommend that the employee go and get tested. So that's the Employment Standards Act leave entitlements. There's also the Human Rights Code. And as I mentioned before, that provides an entitlement for leaves and accommodations in regards to protected grounds up to the point of undue hardship. So the Employment Standards Act, there's no eligibility requirement. You get it if you're an employee. For the Human Rights Code, this entitlement only applies if a protected ground is triggered and only applies up to the point of undue hardship. So what does the tribunal look at for determining undue hardship? It's going to consider things like costs and health and safety requirements. But what's important to be mindful of is that if you're allowing 50% of your employees to work remotely, you're going to have a really hard time claiming that working remotely amounts to undue hardship for everyone else. Now, I specifically want to address the family protected ground. So as I mentioned, one of the protected grounds is family status. So employees are entitled to that accommodation and leaves because of family status related reasons. There's currently 2 tests that are vying for who's going to win the day for how you determine what accommodation needs to be provided in regards to family status. So the first test is the test established underneath Johnstone, and the second one is the test established under Value Village. So Johnstone says, okay, if an employee comes to you and says, I need to work remotely or I need to have my hours of work changed because of childcare needs, that worker has to show that they really do have that legal responsibility, that they've tried to address it otherwise, and that there's going to be a substantial impact if they don't. So you can't, for example, say, I need to work remotely because I want to enroll my daughter in this awesome ballet program. It has to be an actual real need, not something that you're created further to your legal responsibilities. So underneath Johnstone, a worker couldn't decline to enroll their kid in summer camp and then say, I have to stay at home with them because there's no childcare. Now, the Value Village test is different. Value Village says, hey, employees don't have to first prove that they made reasonable alternative, that there were reasonable alternative solutions that weren't accessible. So underneath the Value Village test, an employee could ignore signing up their kids for summer camp this summer and say that you still have an obligation to accommodate them by allowing them to work from home. So which one's going to win? I don't know. I suspect it'll be Johnstone. But as an employer, you should keep in mind that as the daycares and camps reopen, likely with substantial restrictions, when addressing whether or not your employees are going to be placed on an unpaid leave of absence or allowed to work remotely, you should be mindful that the Human Rights Code entitlements will be triggered, and what test has to be met is not yet determined. I would still have a conversation though with any employee who's asking for accommodation because of family status as to what the options are for daycare. Not necessarily telling them that if they ignore them, there'll be a problem, but simply asking them what their options are. So if an employee comes to you and says that they need to take a leave of absence or they have to be accommodated by working remotely or having different hours or otherwise, here are the 4 steps that should be taken. First, you want to review the request and any supporting documents or information that you got. Then you want to determine if the Human Rights Code applies. Is this request further to a protected ground? Is it regards to disability or family status or religion or so forth? Then you need to decide what accommodation is required in order to allow them to perform their job. And then would that accommodation amount to the point of undue hardship? If the Human Rights Code doesn't apply, or what they're asking for would go past the point of undue hardship, then the employee only gets their minimum entitlements underneath the Employment Standards Act. The goal, though, is generally to have an open conversation, and underneath the Human Rights Code, you are still able to ask for documentation, including a doctor's note. Although given the current pressure faced by our healthcare system, I would recommend ask against requiring a doctor's note. There should be other documentation that you can get, such as a letter from public health or the results of the self-assessment questionnaire or the results from a COVID-19 test. Okay, now I'm just going to go through 2 quick examples and then I'll turn over to answering your questions. So the first one, Susan normally worked during the day shift. Her husband watched the kids as he worked the night shift at the TTC. While the company was closed, Susan watched her kids and her husband switched to days, and he wants to stay on days because day shifts are hard to get at the TTC. Susan is now asking if she can work nights on a limited basis when the company reopens. So the first thing you need to think of is, what type of claim is being made here. So this is a claim for accommodation underneath the Human Rights Code. And whether or not Susan is entitled to allowing her husband to continue to work on the days instead of switching back to nights will depend on whether or not the Johnstone test is the correct test. But as an employer, what you should be considering doing is asking whether or not her husband can switch back. And then if he does, great. And then if he doesn't, you have to decide which horse you want to back, knowing that you may be wrong at the end of the day. Example number 2, Steve is afraid of public transit, and so he would like to take a leave of absence for the duration of COVID-19. So Steve has not told you about any actual diagnosis or health issue or disability. So this is not a Human Rights Code request. Steve has also not said that this is because the workplace itself is unsafe. So this is not a work refusal underneath the Occupational Health and Safety Act. Instead, we have someone who's solely entitled to their minimum unpaid leave entitlements underneath the Employment Standards Act. So you can, if you want to, you are always allowed to give more than they're entitled to. So you could say to Steve, okay, you can be placed on unpaid leave of absence, do it as a leave, not a layoff, and issue the record of employment accordingly. Otherwise, you could say to Steve, unfortunately, you're only entitled to 6, 3 personal, 3 family, underneath the Employment Standards Act, and no more than that. Okay, so that's the presentation. I know it's like a lot of information, but I'll now answer any questions that you guys have. So one from Joan is to maintain consistency, do we require a document affirming that employees temporary has been taken to work at home? Employees temp has been taken at home or at work. So I recommend that most of your communication about changes that are going to be implemented be done in writing, be done as a memo. I don't necessarily recommend that you have employees sign off confirming that they've agreed to that. Because sometimes when you prompt individuals to sign something, they feel like there's a discussion to be had and there can be negotiations. I do, though, recommend a signature or signing off or agreement if, for example, you're going to have it so that individuals are going to have reduced hours, but they're electing to use 1 or 2 of their vacation days to top up their pay. So that I recommend having signed off on. If an individual is going to be laid off, but you're still going to deduct their LTD premiums from their pay, for example, then I would recommend that that be signed off. So generally speaking, I prefer to avoid having signatures on the memos, but if there's something that you do actually need the employee to sign off on, or if the employee has an option, you can choose to work in the office 3 days a week or work remotely 5 days you pick. If there's an option there, then the employee should be signing off on it. And then next question from Talia. What if you have all the necessary safety tips in place? Is it necessary that the employee come in at least 1 or 2 days a week as they cannot completely work from home? And if they refuse to come in, unpaid leave, layoff. Okay, so if you have a situation where you have you're complying with the Occupational Health and Safety Act and a person is refusing to come in, again, we go through that process of what are they claiming it under? So if in this instance they're claiming a health and safety work refusal, then what you would need to do is that investigation, you respond to them, and if they maintain the refusal, right, so you'd say to them, we've looked into your concerns, I can confirm, we have these posters up, here's our policies and procedures that we now have in place, we've looked into it, we're complying with all the guidelines that the government has issued, so we're going to ask you to come back into work as of X date. If the worker then responds saying, I'm sorry, but I still don't feel comfortable, then you'll respond saying, okay, well, what we have to do next is we have to involve the Ministry of Labor and they make a determination. So let's say you contact the Ministry of Labor, the inspector says, I've taken a look at everything, everything's okay, there's no basis for the work refusal. Then, if the worker still doesn't come into work, at that point in time, the worker is deemed to have abandoned his job and resigned. So you don't terminate, do not use the language termination or dismissed anywhere. Instead, what you should do is you should confirm that they have resigned and abandoned their job. And accordingly, you'll issue the record of employment with a code for quit. Okay, next question from Leanne. We have an employee that has been off for 2 weeks. He tested positive along with his family. Contact tracing said it was a community spread, and the rest of our staff was tested and we're all negative. What should our procedure be for letting him back to work? And how can we keep the rest of our staff safe and comfortable? Okay, so for everyone in your workplace, you should continue to have you want to implement and have in place those posters, policies, and procedures regarding COVID-19. For the workplace itself, if the worker was in the workplace within 14 days of testing positive, I would recommend having a cleaning company come in and do a clean of the workplace. Once that has been done, all the workers can come back. For the individual who tested positive, once that individual is completed the self-isolation period, then I would only recommend that you allow them back to the workplace if they have been cleared. And given the fact that the government is now allowing for anyone to go and get tested, I think the safest course is to say you either need documentation saying that you can come back in, you're no longer required to self-isolate, or you need to provide us with a copy of the test that says you're no longer testing positive. Because what we're seeing is indications that individuals aren't just positive for 14 days. It's not like there's like a 14-day hard stop and they're magically fine. Some people continue to be ill for 30+ days. So I would say that unless they have a doctor's note, I had one employee who came forward with a doctor's note that said he had symptoms as of this date. And then he was like, well, 14 days have passed now, so I can come back in, right? I'm like, no, that's not how it works. Because if you still had symptoms 13 days later, then that 14-day clock continues to run until you actually test negative. So that would be my recommendation, and that way everyone still continues to feel comfortable with coming into the workplace. Okay, next question from Riza. Are there more specific guidelines from public health on how frequent workspaces should be cleaned? If not, is the general rule as soon as someone touches something, then wipe it down with disinfected wipes? For example, doorknobs to the bathroom, common fridge in the kitchen, etc. So there's a lot of the guidelines are very generic and do not provide specific directions in terms of frequency and so forth. There are some countries like Australia that have posters that deal with, they call them hand washing moments. So if you do things like you go into the kitchen and use anything in the kitchen, that's a hand washing moment. If you use the photocopier, that's a hand washing moment. So because of the issues with obtaining disinfectant wipes, I think it's better to stress on hand washing than using wipes, and make sure that you create clear guidelines in your policies for employees as to when they should be doing those hand washing moments. For wiping down touch points in the workplace, like doorknobs and things like that, most businesses I understand that are operating are doing that on a once-a-day basis, so in the morning or at the end of the day. But other businesses are doing it more frequently depending on the number of people that come in. I think your first step really should be to try to reduce the number of touch points in your workplace. So if the weather's nice and you have an exterior door, keep the door open. There's no reason to have it closed then, unless you're going to have that door locked. So even here at our office for the kitchen, so we used to traditionally close the door so as to not allow food smells throughout the office. But that's just one of those things that we can do by keeping it open to keep the workplace safe. And then many employers are also bringing in businesses to do a deep clean once a week. But I think you have to really make a decision on how much traffic do you currently have in your workplace? How easy is it for individuals to regularly wash their hands? And just always remind yourself that you don't want to have an incident of COVID-19 in your workplace. You do not want to be that employer. So do take all reasonable precautions in order to avoid it. Okay, so I'll take one more question from Joan. Recently heard of a company where for insurance reasons, employees or on-site contractors are required to sign a waiver that they will not sue the employer if they contract COVID-19 in the workplace. Is that something you've heard of? So I know that employers are concerned about lawsuits in regards to COVID-19, and it's not helped by some lawyers out there who are going on the news scaring people about what's going to happen. I will say this though, there was a private member's bill introduced last week to have the WSIB confirm that all COVID-19 work-related cases are going to be insured by the WSIB. So as an employer, if you're covered by the WSIB, what that means is that no worker will be able to sue you if they contract COVID-19 in regards to the workplace. So if you are currently insured with the WSIB, you will have that protection in place. If you are not currently insured with the WSIB, now might be the time to think about registering for coverage. You can elect to be insured. And I'll also note that the WSIB also currently provides insurance in regards to workplace mental health issues and harassment, which it didn't previously. So it's a pretty good insurance coverage regime. So I think that a lot of the potential lawsuits or litigations that might have happened in regards to COVID-19 probably will be eliminated because of the WSIB. But for those workplaces who don't have it in place, I'm not sure under what tort they would claim it. I don't see the path there to a successful litigation, but there's always paths to stupid litigation. So, all right. So, barring any more questions, thank you all for coming out, and I'll turn it back over to Nicole.
Thank you, Christine. A huge amount of information there for all of us to digest, but really appreciate your availability and the presentation you've put together for us. We are recording it, so we will have this presentation available on our website afterwards, and we can circulate to the attendees as well. And just to remind you all, in a minute, that we have a number of exciting webinars coming up this week and into next. Our next one tomorrow is May 26th. Now What? Navigating a New Normal for Business, presented by ThriveX Consulting. On May 28th, we're running a Excel tips and tricks, so upgrading your skills while you're working from home, presented by JN Software Consulting. And then June 2nd, we are putting on a session around tweaking your networking for online virtual events. So that will be next week. With that, it is 10 o'clock. I will say thank you all so much for joining us. We'll see you all soon. Thank you again, Christine, for the presentation. And anyone who has any questions, please feel free to reach out. All of our staff are available by phone. You can leave us a message and we'll check those, or by our email. So with that, have a great day, everyone, and we will all be in touch soon. Bye for now.